is 12% of the state exam. All right, so this is pretty much, this chapter is all about the broker, even though the whole book's really all about the broker. This goes into brokerages and how they should operate. I want you to know that brokerage offices must be of stationary construction. The broker must have an office, right? Stationary means it's not an RV on wheels. And that sales associates may not operate offices of their own. If they present you an example that the sales associate is operating an office, you're going to go with that it's a third-degree felony, right? Unlicensed activity is not licensed to operate an office. Branch offices. We talked about these, right? The main thing I want you to know is that they're not transferable. Now the office side. What you see up there is what must be on every brokerage office sign. It must be at the door or upon immediately entering into the office. And it's going to include the name of the brokerage firm, the name of the broker, the word licensed real estate broker. License may be abbreviated LIC. Okay? It doesn't have to have the address, the phone number, or none of that, because that's what they're going to throw at you at the state level, making you think that, you know, something else has to be there. This is all that has to be there. No address, no phone number, etc. You can place, however, obviously the phone number and all those other things, and you can place associates' names on the entrance sign. However, there must be a line separating the top three that must be in that order from the associates that would go below. Advertising. Anytime that you are advertising, there's one thing that must be included in your brokerage firm, in your advertising, and that's the brokerage firm. Nothing else has to be there. I can pay for a billboard on the Palmetto and put ABC Realty on it. I don't have to put my phone number. I don't have to put the address where I'm located. I may be in a one-horse town somewhere in middle Florida of where they know where to go find ABC Realty. All right? So there's a question on the state exam that says what must, and the only thing that must be there is the name of the brokerage firm. Other things are optional. And now when you do include other things in your ad, you must follow certain guidelines, and we'll talk about them now. Such as your name. As an associate, you're going to want to put your name, you're going to want to put your phone number, probably your senior pick from high school in there too as well, which most agents do. And you could do that, that's fine. But if you include your name, you must include your last name. So you can't just call Jack, right? Must be called Jack Suarez. And if your name is, let's say Joaquin, and you go by Jack, well then the Joaquin has to be there, Jack has to be in parentheses, and the Suarez must always be there. Furthermore, you're going to want to include your personal number, right? Nowadays, you don't want the phone calls coming into the office and for another agent to maybe get your lead. So when including your phone number, however, you must include the words cell or direct behind that phone number. So you're pretty much telling them this is not the office number, you're contacting me on my cell, or you're contacting me direct. All right? So last name always, you use a nickname, you got to include the first name, and you need to let them know that they're calling you directly and not the office. If you fail to do any of the following, it's considered blind advertising or false advertising, and that would be a second-degree misdemeanor, right? There's a victim or a potential victim, right? The public is not aware that you are licensed. Internet advertising, at any point you're advertising on the internet and they can contact you, the name of the brokerage firm must be there. It's not enough to have the name of the brokerage firm all the way at the bottom of the website in very small print and have your name and your phone number throughout the rest of the webpage. No, at any point, that they can contact you, which means send us an email, your phone number, your address, any way they can contact you, the name of the brokerage firm must be adjacent. I can sit here and nitpick. Probably 80% of the agents in town don't follow this. They're going to start cracking down on it as per their last meeting. In particular, team concepts, which are really big right now, and teams are advertising their team name and seem to be excluding out the actual brokerage. Pretty big at Keller Williams. Everybody forms teams there. And for whatever reason, they rather advertise their team name other than KW, which is supposedly the #1 brokerage currently in the United States. If you sell your property by owner, we used to have to put owner agent in the advertising. That's no longer the case. If you advertise your property and you're selling it by owner and your broker gives you his blessing, at point of meaningful negotiations is when you need to disclose that you're licensed, okay? Telephone solicitation, the use of telephone to encourage someone to buy or sell a service or a good. You must check the do not call list. If they're on the do not call list, you can't contact them, with 3 exceptions, which we'll talk about now in a minute. Outside of that, if they're not on the list, you can contact them only between the hours of 8 a.m. and 9 p.m. Okay? There is a Florida law and a federal law. If you break the do not call list, which I don't really think they force this that much, because I have Obamacare, my car warranty's been up for years now, and all that other good stuff calling me, and I'm listed and I report one in particular that's almost borderline harassment, and they still call. So federal law $16,000, that's a lot of money. Florida law is $10,000. Now here are the exceptions, and there's 3 of them. The first is when representing a bona fide buyer. You can contact a for sale by owner if you have a buyer for his home, even if they're on the list. And you can contact individuals with whom you have done business with for up to 18 months after that business was concluded, even if they're on the list. Again, I'm teaching you, the law, not so much. You may want to keep in contact with your clients and customers for a little longer than that, right? But if they're on the list, this is what the law states. And then the third is somebody who made a business inquiry, meaning maybe they saw your yard sign in front of a property, they contact you asking about the property, they say they're looking in the neighborhood, you capture their phone number, you can call this person for up to 3 months. Any questions? Jesus.
What about those people that advertise online and then you enter the information because you're interested in looking at the property, but you're on the do not call list?
So that 3 months. You made an inquiry out to that agent. They captured your information. They can contact you for up to 3 months. Escrow or trust accounts. An account for the deposit of money the broker holds in trust for others. The deposit is the money delivered to a licensee in connection with the real estate transaction. You need to give a deposit on a contract? It's a question. Do you? No, that's on the state exam. You do not have to give a deposit on a contract. Because consideration can be either valuable or good. Alright, so immediately defined. The sales associate must deliver immediately to his broker any money entrusted to him or her by the end of the next business day. And then the broker has no later than the end of the third business day to deposit that money into the escrow account. The example on the state exam says that the sales associate delivered the money the very same day. What happens? Nothing changes. It's still 3 nights that the money can stay within the brokerage. However, the sales associate must give it the next day. If he gives it the same day, the broker still has 3 nights to deposit it, right? 4 days, 3 nights. So here's an example. Money was given on a Wednesday. When does the money have to be delivered to the broker? Thursday. And when must it be deposited into the escrow account? Monday. If you went to Gold Coast, you didn't see this one, but it presents itself on the state exam. Somehow, the buyers didn't get instructions properly, and they write the escrow check to your name personally. What can you do? You can endorse the back of the check and turn it over to your broker immediately as defined, which means end of the next business day. You can actually accept it. Okay? There's also something in the Gold Coast book that doesn't present itself in this subject, this material, and that's that. And it used to. I don't know why they removed it. You can't offer property by luck, chance. You can't offer a lottery pretty much to buy property as a licensee. Post-dated checks. You can accept a post-dated check from a buyer. Again, a deposit's not needed. However, if you do accept a post-dated check, the broker must get the okay from the seller. Okay, so the seller must be okay with the fact that you're holding the post-dated check, and as soon as that check becomes good, it must be deposited immediately. Now the broker has literally the next day to run it to the bank. Here are the acceptable depositories. For state exam purposes, you want to know that insurance company is not an acceptable depository. Okay? Commercial bank, credit union, savings and loan association, title company or attorney, and all of these start with Florida because the money must be kept in the state. You want to know that for state exam as well. Now, if you're going to use a title company or an attorney, certain different things must be done, and we'll talk about those in a second. The first one, before we go there, let's talk about interest-bearing escrow accounts. The escrow account can earn interest as long as everybody in the transaction is aware that it is earning interest. And what you'll find on the state exam is that the broker can be the one earning the interest and he can keep it. Right? But everybody must be okay with it. Now, money to maintain escrow accounts, right? Escrow account is an account for the deposits of others, right? You should not be commingling, meaning mixing it with your own money. But there is certain thresholds that they allow for you to mix that money. If the escrow account is for sales, $1,000. You can put up your own money. If it's for property management, then it could be $5,000 of your own money. And the question on the state exam is, the broker uses the escrow account for both sales and property management. How much of his own money could he put in there? No, 5,000, the higher of the two. So don't fall for that one on the state exam. You'll find that on the state exam. So in the case it's 5,000, it would be the higher of the two if you use for both. All right, notice and settlement procedures. So sometimes deals don't close. Buyer and seller are not in agreement with where the escrow money's to go. The seller's making a demand, buyer wants it back. You have what's known as conflicting demands. The first thing you must do when you have conflicting demands is notify FREC. Let them know, I have this issue within 15 business days. Then your next step would be within 30 days to implement one of the settlement procedures. We'll talk about those in a minute. On the state exam, it tells you that the broker notifies FREC within 14 days that he has conflicting demands. How many days does he have left to implement one of the settlement procedures? 30? 16 days. They run concurrent. The days run together, and I'm pretty sure from what the students have brought me, it's exactly 14 days. You pick 16, you'll be good. So know that they run concurrent. So now you let them know you need to implement one of these settlement procedures. MAIL is the acronym to remember it: mediation, arbitration, litigation, and escrow disbursement order. Mediation, you sit down with the mediator. It's kind of pointless. Walk in. The mediator suggests this is what I think should happen, etc. Usually both parties leave there even angrier because they had to see each other. Arbitration, however, you sit down with the third party disinterested. This is the ideal situation. Here's both sides of the story and makes a binding decision. Based on what I've heard here today, you guys should split the escrow or whatever the arbitrator decides. Here in Miami, though, it goes to litigation, right? I'm going to sue you. I'm going to pay my attorney $5,000 to fight over $5,000, and the attorneys win. Makes no sense. But here's what's on the state exam. Brokers may have an interest in the escrow money. Our listing agreement states that any deposits that are held or given to the seller, the broker's entitled to 50% of it up to the amount of the commission. But if the broker has no interest in that escrow money from the seller, he would place the money with the courts in interpleader. All right, that's what's on the state exam. You want to know that the money is given to the court interpleader when the broker will make no claim on the deposit. If the broker is going to make a claim on the deposit, the broker would keep the escrow money in his account. And then the last one is an escrow disbursement order. Frank makes a decision as to where the money will go. If it ever gets settled and you do an EDO, you must let them know within 10 days that the dispute was settled so that Frank does not waste their precious time on the EDO. Now, there are a few exceptions to implementing one of the settlement or escape procedures, as they're known as, and that is when there is the sale of a HUD-owned property. HUD tells you off the bat, you give me a deposit, we accept your offer, you don't close, deposit's ours. Second one, timely notice to cancel a residential condo contract. We'll talk about this after lunch, but you have certain days when you're purchasing a condominium to receive the documents and decide to move forward or not with the transaction. And then the last one is failure to satisfy the financing clause. And this is why most reasons that deals die and the buyer just gets his money back. Right? There's a clause within the contract that says that the buyer has up until certain date to obtain financing. If they don't successfully obtain it, then the money is just given back. Here's the rental information in this. We talked about this before, right? You want to know the 30 days, 75% if they don't obtain a rental, even if they change their mind, 100% if somehow there was an error on there that was not intentional. Sales associate commission, right? Paid by the broker. Even though he tells the title company to pay the sales associate, it's under the control and direction of the broker, right? Broker's commission. Alright? Who sets the commissions? The broker. Not the board of realtors, not FRAC, because you have a question like that on the state exam. The broker can choose to charge what he wants to charge. Alright? And the broker can share his or her commission with the buyer or the seller in the transaction. You can never pay a party outside of the transaction unless it's another licensed broker. Even if that broker's licensed in another state, we can pay them a referral. So there's the example of the broker that has a client from New York. They come down to Florida. He refers it to a Florida broker. What could that other broker do? You're going to want to choose that broker can stay in the hotel room and enjoy the pool. Because the other broker's entitled to a referral. Customary is 25%. Maybe you're giving them half. Florida doesn't mess with that. But Florida will not permit him to go with you showing the properties. So if he comes down with him, he stays at the hotel. Right? But you can legally, or the broker can legally pay a referral to that other broker. Now, brokers establish their own commissions, right? But brokers can't conspire with other brokers to set commissions. It would be a violation of the Sherman and Clayton Antitrust Act. And there's a question on the state exam, their Key West brokers get together, because this could only happen in a small town, really. A few of them get together and say, hey, Jim, why did you lower your commission to 5%? Now I have to lower mine. Why don't we all charge 7%? Can't do that. It's a violation of the Antitrust Act. Furthermore, they can't conspire to split up the market. So, hey, you want to charge 5%? Sure, but you stay in your part of town. Don't come into mine. I won't go into yours. That's known as market allocation, which is a violation of the Sherman and Clayton Act as well. Liens on real property for unpaid sales commission. If your listing agreement has lien rights in it, and you feel like you're getting circumvented as far as your commission goes, you can lien the property for payment. Otherwise, you must seek a civil judgment. Unfortunately, one of my first transactions, I know this one very well, I had to do this on. I had a listing where the guy was extremely eager to sell. We lowered it. We finally got to a point, about the 4-month point in the 6-month listing agreement, of where the price was right. We're getting activity, find a buyer. Buyer comes like twice. The third time he brings grandma and his cousins and the whole 9 yards. The guy disappears. Then the seller all of a sudden wasn't all over me to sell his house. Oh, I'm working late tonight. I can't show it. I won't be home. Blah, blah, blah. So as the listing agreement came to an end, I placed the lien on the property and sat back and waited for the phone call. Got a call from a title company. Hey, why do you have a lien on this property? Oh, I had it listed. By the way, is the buyer so-and-so? Yeah, well, I procured that sale. I'm going to get paid. They just waited for the listing agreement to expire to put the deal together themselves. They figure, oh, well, we got to wait. It's like 6 weeks. Meanwhile, you get your mortgage going. And, a week after the listing expires, we'll close on it and won't notice. Now, my listing gave me those lien rights. Otherwise, I would have had to wait for it to close, to prove it, then sued in court and obtain the judgment, and then maybe place the lien on that property. Or there's other ways to collect on judgments, and we'll talk about that after lunch. Now, when it comes to commercial real estate, works a little different. Part 3 of Chapter 475 has to do with commercial real estate sales. Okay? If you are circumvented in a commercial transaction and it is a sale, under Part 3, you can lien the seller's proceeds, not the property. Well, when they came up with this part to 475, they failed to realize that commercial leases are also extremely lucrative, right? And we can get circumvented there. So they added Part 4. Part 3 sales, Part 4 leases, works the same way. You can only lien the seller's proceeds. All right, kickback, rebates, and unearned fees. If it is a service-related industry, you can never give a kickback unless you're properly licensed under that. For example, if you're a loan officer as well, you have a MLO license, you can ask for another loan officer to give you a kickback. Otherwise, you cannot. So anybody who helps you take it from finding the buyer to closing, you can never give a kickback, or they can never give you a kickback. Such as the title company, mortgage company, home inspector, appraisal, etc. And you can never give somebody who's unlicensed a kickback other than if it's the seller or the buyer, right? And that would come from the broker. However, you could receive a kickback, for example, for referring a handyman to a buyer. However, the buyer, seller, everybody in that transaction must be aware that you really need those $100 for referring a handyman to the buyer. If not, it would be a RESPA violation. And then the last thing I want you to know from this chapter is on the screen now. These are the 6 entities, or corporate entities, you could say, that you can use to incorporate a brokerage. It could be a sole proprietorship, a general partnership, a limited partnership, a limited liability partnership, a corp, or an LLC. Look out for corporation sole. They always like to throw that one on. A corporation sole is a church. So, since it sounds like sole proprietorship, they like to present that on the state exam. Don't go with that one. What else do I want you to know is that general partners in a real estate brokerage who deal with the public must be licensed brokers. Here's the thing, is you could be a general partner in a real estate brokerage and not have a license, and it's fine. But you can't be a sales associate and be a general partner. So those that deal with the public must be brokers. However, sales associates can be limited partners or shareholders. You'll find that on the state exam. General partners who deal with the public must be licensed brokers. Right? So you can be a general partner, unlicensed, you don't deal with the public, good. However, if you're an associate, you can't be a general partner, but you could be a limited partner or a shareholder.
As sales associate, can you be a general partner who doesn't deal with? I know that's unusual.
Well, if you have an unlicensed, if you put your license inactive and you're a sales associate, sure. You don't deal with the public though. So if you're going to deal with the public, you must be a broker. But a licensed sales associate who is active cannot. All right, guys, let's take like a quick 5. I do skip 6. Go ahead.
When you say the refer, we as a sales associate, we can pay the referral, or the broker needs to pay the referral?
If you ever get a referral yourself, it must go through the broker, right?
So
And if you pay a referral out, it should come from the broker as well. Yes.
Okay.
Correct.
Thank you.
Everything through the broker, guys. Remember that.
Okay.
All right, let's take a quick 5 and we'll resume.